Your Honor, Dave Nelson on behalf of Paula Anderson.
I see an Eric Miller. Can you hear me, sir?
I'm not sure. I'm trying to figure this out. The app
I can
is
hear
there.
you now, so can you hear
Okay.
us?
I can hear you. I just don't know how to turn the video on.
That's fine. Any objection to proceeding without video, counsel?
No, Your Honor.
Okay. Um, so I did have a chance to go through your pleadings on both sides, memorandums of law, and I'd be happy to hear argument, if any, you'd like to make.
Let me go through a bit of the background, and I know this will cover some of what you've read, but this involves the purchase and sale of the All-In Saloon, which is on Commerce Avenue in Longview. There is a private arbitration clause in the contract. I initially started the case by filing a complaint. Mr. Miller brought a motion to change venue to Clark County. Judge Carmi denied that, but she also stayed the complaint or stayed the action pending arbitration. So then on a couple occasions, sent a list of arbitrators, which were attorneys or judges from Clark County, to Mr. Miller to try to select an arbitrator, and I've just been met with a stone wall. He's demanded a statement of arbitration issues, which I don't think is necessary since it's a private arbitration that's agreed to in the contract. He's imposed 30-day deadlines that really don't mean anything. So I'm here to ask the court to pick an arbitrator. I've given you the three names that I've given him, and I think they're qualified to hear this case. I don't care which one the court picks, but somehow we need to get this moving forward. And then finally, Mr. Miller's brought a motion to dismiss, but I don't think that has been properly noted at this point and should be denied for that reason.
All right, thank you. Mr. Miller?
Your Honor, Mr. Nelson seems to have left out a piece, which is why in my Exhibit A, I actually gave the entire email chain. I immediately responded to him immediately after Judge or Commissioner Carmi's order saying that he had no right to file in Cowlitz County, that he was supposed to have filed in Clark County, but she stayed the case since the business itself, even though the contract says Clark County, the business was registered out of Clark County, the physical address was in Cowlitz County, and said that we would be done in arbitration. I assumed we'd actually be done by now. And then in my email chain, you can see that Mr. Nelson then dropped off all communication for over 6 months with no communication of any kind in any way, saying whether he wanted to, because the order from Judge Carmi was not this has to go to arbitration, that if he chose to take it to arbitration, he needed to take it to binding arbitration in Clark County. I never received a notice after I immediately asked him, would you like to go? And then he dropped off communication for 6 months. So when he picked communication back up, I then requested, I would like to know, what is it you would like to arbitrate? Because the case was stayed because you didn't want to do anything. You just dropped off the face of the planet. Her previous business partner, who's also on the contract, is, I assumed, part of the reason why, because she wants to testify for me, not him. So logically, I came to the conclusion that the case may be getting dropped and he no longer wanted to pursue it. I also stated that when it said binding arbitration in Clark County, we were following the arbitration rules of Clark County and the RCW, which I quoted, which states he should send me a notice, and then we would have a statement of arbitrality out of Clark County that we have filed, so that way, if there were any issues during arbitration, it would be heard in Clark County. And then in regards to the motion to dismiss, the motion to dismiss is so that Mr. Nelson here will stop bringing orders that require me to travel up to Longview to try and get me into Longview, because obviously he's doing some sort of delaying tactics or whatever to try and keep dragging this on over and over again. If he wanted to do this, I was ready to do this and requested, let's do this in January of this year. This is a year long later, and he's just now getting around to it, but won't provide anything, which was a simple request. And that self-imposed 30 days notice, Your Honor, was just very simply, I'm not going to keep dragging this out and expect another communication in 6 months. If you'd like to do this, let's do this. Tell me what you'd like to do. Otherwise, I'm going to keep moving on.
Your Honor, Judge Carmi found that there was no venue clause to be enforced. That's why she didn't change venue. All it says is that it will be arbitrated before a Clark County arbitrator. I proposed 3 Clark County attorneys. Presumably, the arbitration would be held in Clark County with them. I'm certainly willing to have it there. We just need to select an arbitrator, and Mr. Miller has not cooperated in doing that. Thank you.
Okay. So what I could gather from the file, the case was filed here. There was obviously a motion to change venue that was denied. So the case is still situated in Calhoun County for the court case with the direction to do the arbitration in Clark County. You're still under this court case for arbitration in any enforcement of that, even though it would be physically or procedurally arbitrated in Clark County. So it seems to me that there's, whether there's a formal statement of arbitrability or not, it was a directive by the court. If you want to take it to arbitration, do that outside of the court process in Clark County. And that's what's being attempted to be done. And that's apparently what needs to be done. A couple of other concerns. So my inclination is to go ahead and pick an arbitrator so you guys can get this resolved. My inclination would be to go with Mr. Bennett only because he's the only one I'm familiar with at all. I'm a prior judge in Clark County, so I'd be inclined to pick him, not hearing any objection otherwise. One thing that does raise a concern for me from a process standpoint, and this is just a comment to Mr. Miller, you're representing yourself pro se. Legally, you need to have an attorney represent the development LLC because of they can't appear through a pro se party. They have to appear through an attorney. So you may want to look into that.
Real quick, Your Honor, why would so the LLC would need a lawyer? I don't understand what you're saying.
That's correct, because an LLC has to appear through a lawyer in court, just like a corporation has to appear through a lawyer in court. They don't appear through the partner, the managing partner, because that's not, state law requires a person representing somebody in court to be an attorney. I assume you're not an attorney. Because you're listed pro se. So you may want to look into that because technically, and not realistically, you can't represent the Ragnarok in court. You can represent yourself clearly because you're pro se. And it looked to me when I reviewed the contract, I assume you're responsible if you signed for the development company as opposed to for yourself. Then it's unclear to me whether or not you're even a necessary party to the case. But if you signed as yourself and Ragnarok, then you'd be a party to the case. But Ragnarok needs to have an attorney.
Okay.
Not for the arbitration, I don't think, but for purposes of the court case. So.
Understood.
Okay. So I don't have an order on. I don't believe that it's...
Your Honor, I didn't submit when I didn't know who you were going to pick. So I will fill in an order with Judge Bennett and submit it to you on Monday.
Okay. You should probably send a copy to Mr. Miller also, just so he's got a copy of that.
There was a proposed order with just a line.
Oh, okay.
So he's seen the language of it.
Okay. All right. So assuming you can get that to me, I'll get that signed early next week.
Okay. I'll route it to you next week. Thank you, Your Honor.
All right. You're welcome.